Welcome back to Sunrise Daily. We've got Mr. Norris Quakers, Senior Advocate of Nigeria, to weigh in on the matter as well. Thank you for coming on this morning.
My pleasure.
Well, we've heard several, we've read several jurisprudential extrapolations about this, particularly the case in Ganjura versus Federal Republic of Nigeria, several ones, even involving the CCB themselves. But from your perspective and legally speaking about this particular matter, is this in order?
Not quite. Let me start by saying that this issue has actually been laid to rest. The challenge we have, we also don't have a reading public, so it's also an issue. We operate, as it were, a constitutional democracy, meaning that the rules have been set and provided for in the Constitution. Therefore, if you look at the Constitution, what does it really say about situations like this? Now, some people have argued that the NJC cannot look into a matter like this. Now, the same CCT had cause to make a pronouncement in respect of this involving Justice Sylvester Nguta. This was, I think, the last year or so, when he was also arraigned before the Code of Conduct Tribunal. And then an objection was raised, anchoring that objection on Ngajua. And the tribunal upheld the position and dismissed the criminal allegation, as it were, before them. Now, if a CCT had already taken the decision in respect of this, and incidentally, the chairman at that particular time is actually the current chairman now.
So if he declared himself incompetent to look at that matter at that time,
yes.
Why then was it
nothing has changed, and so that's why some of us are a bit worried. I feel, and I will say this, that the Nigerian Bar Association should also take steps, because this is actually an embarrassment to the federal government of Nigeria. And the lawyer who initiated this charge or initiated the suit or the proceedings should be placed before the Legal Practitioner Disciplinary Committee. It's an embarrassment to government. The issue has been laid to rest as far as trial of judges of the Federal Republic of Nigeria are concerned.
But does that mean, by implication, you submitting that they are above the law?
Certainly not. Let me. The beauty of, and that's why I said we have a constitutional democracy. The beauty of all of this is this. Now, are you aware that the CJN can be removed? And it's also provided for in the Constitution, Section 292. Now, the procedure for his removal is 2/3 majority of the Senate. Now, because the role the president plays in relation to his appointment is one of submission of the name, approval or suggestion for appointment comes from the National Judicial Council. So the president is then now mandated to forward the name of the person approved for the appointment of Chief Justice of Nigeria to the Senate for what they call confirmation hearing. Once the Senate has confirmed a particular person to be appointed into the office of the CJN, he then goes before the president for his swearing in. Now, if you notice, before this particular appointment, this particular Chief Justice had issues in relation to his appointment. The appointment was delayed. He was eventually appointed when the acting president stepped in as acting president. So the issue is also there. And then at that particular time, a number of lawyers came up and said, no, Mr. President, you have no discretion in this matter. When you look at the Constitution is very clear on this. All you're expected to do, put forward the name. The aspect of nomination actually comes from the National Judicial Council. Mr. President, once the National Judicial Council has done what they call in-house finding and cleaning and forwards the name to you, you forward the name to the appropriate authority, the Senate. Now, once the Senate confirms, the name comes back to you, you fix a day for the swearing of the CJN. Now, so that's one particular procedure. Now, where the CJN is found to have abused his office or has done a number of things, his removal is actually by 2/3 majority of the Senate, and it's there in Section 292. So this, for me, is actually not an issue. And I'll give you a particular example. Aspect of declaration of assets is provided for in the Constitution. Therefore, if your assets are not declared, or you have underdeclared, or there's false declaration, there's also a provision in relation to that. Now, are you aware that the interpretation section of the Code of Conduct refers to failure to declare assets as misconduct?
Not a criminal offense.
It refers as misconduct. Therefore, in relation to the decision of Ngajiwa and Federal Republic of Nigeria, if you must discipline a judicial officer in court for misconduct, what do? You forward the name to the NJC with your findings. NJC will look at it. Look at what happened in Ghana. I don't know why this is an issue here. Judges in Ghana, after the finding by the journalists, were found culpable. A committee was set up to investigate the various allegations. When they were found culpable, recommendation was made for their dismissal. In addition to that, after the recommendation, they were then now recommended for criminal prosecution because of the nature of the offense that they had committed. But first, you see, the NJC has to step in. Now you have a CJN who is occupying the office, and the Constitution says that if for any reason you want to remove him, you need 2/3 majority of the Senate. So question is, what do? If the Court of Appeal has stepped in to say all judicial officers, before they can be disciplined, you must first seek the attention of the National Judicial Council. Question is, have you done that here? You haven't.
If in this case, as we did have your learned colleague, Mr. Obani, who was here just a moment ago, said that his lawyers can actually go to represent him and file in maybe some papers in court today because he's expected to appear today. But if that is what is advised that he do now, what then would you say to our concerns raised around, say, since that's the process that will engulf this whole issue, he can step aside?
No, certainly not. And that's why I said, why should he step aside? When the law is also clear on this, the aspect of stepping aside is also not provided for. If you look at the Constitution, I don't think we should read anything into it. And a particular example, for instance, the CJN can go to court through his lawyers and file a preliminary objection and not even show up because it's challenging jurisdiction of the tribunal to hear and determine a matter against him. More particularly and more fundamentally, the same tribunal last year involving Justice Sylvester Ongota had made a pronouncement on this, relying on the decision of Ngajiwa. What has changed?
So when you then say that the lawyer that filed this case should be placed before the disciplinary committee of the NBA,
yes,
what happens? Because he went to court, the charges were approved. What happens in both cases? Should it just be him or both? Which one?
No. For me, it's more like him. You have taken a step that has now embarrassed the federal government. I hope you are aware that under our rules, when a lawyer sets out to mislead, there's a presumption that we're expected to know the law. You could have what is called innocent mistake, right? So there's a presumption that all lawyers are expected to know what the legal position is. One of our seniors a while back said he went to England and he was canvassing a legal position. And the English judge looked at him and was wondering, what is this guy saying? And then eventually now said, oh, have you read this case of so and so? And he said, well, he hasn't. He said, okay, I'm going to stand down your matter. You go to the library, read it up and come back and let me listen to you. Now he went to the library, read the case, came back to the court. And the judge now asked him, so what's your position? He said he urged the judge to discountenance all that he had said, haven't been privileged to read the current position on this issue. Guess what the judge said to him? The judge said, if you had continued with that line of argument, after being exposed to this current state of the law, I will report you to the Law Society as one who is not fit and proper to practice law in this jurisdiction, in England and Wales. Now, that is a system. Now, do we have something like that here? We do. But the challenge we have is we are politicizing everything. And that's the danger.
I was going to ask you, does this in any way take away from the fact that the CJN is alleged to have breached the code of conduct?
Certainly not. If indeed, and that's why I started by saying that there's nothing that we're discussing that is not provided for in the law. There's a procedure. Just follow the procedure, just follow the process. If the court has stepped in to say, mind you one, all judicial officers are expected to declare their assets. All judicial officers, without exception. Now, if you have been found to have falsely declared or underdeclared or misrepresented facts, as it were, and then investigation has not been conducted, now the National Judicial Council now says, oh, look, we are responsible to take certain steps. When I say this, and I say it with all seriousness, you don't take a Chief Justice of Nigeria who is currently serving and dock him. It's not about the person, it's about the office. And that's why AJC said, look, let's look at it. First, take certain disciplinary steps by saying, okay, we found you culpable, step aside. But in relation to the CJN, because it's the head of an institution, the Constitution now says in Section 292 that such an office holder can only be disciplined by the Senate, by 2/3 majority of the Senate for his removal. It's as simple as ABC.
So what would you recommend now? Should he appear, or should his lawyer just go file charges, challenge jurisdiction?
No, the law on this is very clear. I want to believe that because of the team of lawyers that have been assembled in respect of this, a preliminary objection will have been filed. And when you file preliminary objection challenging jurisdiction, you don't have to be there. So it doesn't have to go.
Let me get your thoughts on the South-South governors who are, by and large, behind in support of Onaga himself. But their submissions, when you hear what they say, are you in agreement that this could, as you say, it is politically motivated, but can it go further than what it is right now? Because the fears are that if the South-South and the militants, in the Niger Delta, say that they'll begin to foment trouble and attacks, will that happen?
No, you see, I'm not a politician. I don't make political statements, and I'm also not sentimental. Now, the position of the governors flows from a political position, not one that is based on law. For instance, advising the CJN not to show up without recourse to what the legal dynamics are. And that's why I started by saying that, for instance, if it's challenging jurisdiction, he doesn't have to appear. And now this is someone who is the embodiment of the Nigerian judiciary, advising him to stay off without filing a preliminary objection, challenging jurisdiction as we're taught, as what the law is, will simply mean that you're encouraging him to disregard. But the aspect of blowing up pipelines and militants coming on, that for me is political, and the country is so sensitive for such
let's wind down with this one. Is there any similarity in this case and that of Justice Salami during Goodluck Jonathan's time?
Yes, but the only difference is the Attorney General at that time perhaps advised the government at that time not to take certain prejudicial steps. And now if you notice that of Justice Salami, it was Salami that actually went to court to challenge what was good. There was an attempt to remove him from office. And when they saw the constitutional provision, they backed down and allowed him to continue to fight towards his reinstatement until the statutory age of retirement was reached. So a fait accompli was created in the case of Justice Salami. That's not what we have here. I mean, we're looking at, are you aware that the current CJN was the one that constituted the current Code of Conduct Tribunal? In the military, for instance, I've been privileged to appear in court martials. When a general is to be tried, he's not going to sit with lieutenant colonels. I mean, it's shocking and it's irritating that we're expected to know the law. We know what the law is. And then you now, on the altar of political expediency, put together what you consider to be a criminal charge, and then you serve it on the CJN, and you expect him to appear at the tribunal. That, for me, is not, it doesn't augur well for our fledgling democracy, and it's something that any discerning mind should look at and advise the government. President has come on air to say he's not aware. If he's not aware and the Attorney General is not aware, then the government should do the needful by withdrawing the charge. Just go there and file a notice of discontinuance, and we'll withdraw the charge.
Always a pleasure to have you on, Mr. Norris Quakers, Senior Advocate of Nigeria. We appreciate your coming on this morning.
My pleasure.